September 27, 2012. It's just done dirt cheap. Just want to share some thoughts regarding pleas. Just want to give some basic information regarding bylaw matter pleas and Criminal Code of Canada pleas. Now, what a plea is your statement to the court of whether you are guilty or not guilty. You have one or the other. It cannot be both. It can't be a little bit of one, a little bit of the other. It's either guilty or not guilty. Now, first, bylaw matters. With a bylaw matter, one is usually requested to make, or required to make a plea on the first hearing. So if the bylaw matter is scheduled, day one, the judge is going to ask for a plea. The judge will read the charge in whatever language the individual prefers, French, English, or otherwise, and the court will ask, how do you plead, guilty or not guilty? Now, one can choose guilty or not guilty, or say nothing, and the court will enter a plea of not guilty on their behalf. Now, what's interesting is that people don't realize you should never ever plead guilty to something you're not guilty of. On the other hand, why would you plead guilty to something you are guilty of? Because the way the system works is it's up to the ones making the charge to prove their case beyond a shadow of a doubt. Which means it's not, in civil matters, one has to prove a case more probable than not. As in, it's more probable this thing happened that you're alleging than not. You can win that way. In criminal code, provincial court, bylaw matters or criminal code matters, the Crown, or the lawyer representing the city, must prove their case beyond a shadow of a doubt. Which means if the judge has any doubt that the person is guilty, the judge should enter a not guilty verdict at the end of the trial. So, whether one is guilty or not, it doesn't do someone any good to enter a guilty plea unless they're just planning on paying the fine or just doing the penalty. The same applies to Criminal Code of Canada matters. So if you're being charged with a crime, it's the same procedure. There's a plea date. One's asked by the judge, do you enter a plea of guilty or not guilty? If you don't plea, the judge will enter not guilty on your behalf. Now, what's interesting is once you enter a plea, it's considered that you've attorned to the jurisdiction of the court. Attornment is a legal term that you're giving something to them. You're giving something to them that they did not have otherwise. Historically, it was commonly used in leases, where one would attorn a lease for land or property to someone else, which means they gave the lease over to someone else. In legal speak, it means giving over. So what's interesting is, before one enters a plea, the court doesn't really have jurisdiction over the matter, or at least not personal jurisdiction over that party. It's only after someone pleads that they're considered to have returned to the jurisdiction of the court, and the process moves forward. Now, I've heard many stories, talking to people one-on-one, where they've explained how they were not guilty, but they entered guilty pleas because they believed they would have a lesser sentence or the matter would be over with sooner. Now, it's actually not lawful or legal for the Crown Attorney to make these deals where they offer a lesser sentence if someone enters a guilty plea. You cannot enter a guilty plea if you're not guilty. That would be fraudulent, not correct. I'll go on your left here, sorry. So what's interesting is there's actually a lot of illegal conduct occurring in the courts, and the illegal conduct is on the part of the Crown prosecutors and judges, because judges are accepting guilty pleas for people who are obviously innocent. And what's interesting is that it's not legal for a Crown attorney to make a deal with someone who is innocent and promise them that if they plead guilty, that they will get a lesser fine or jail sentence. So, lots of illegal conduct going on in the courts. So I want to bring that to your attention. Now, I've talked to many people who have made these plea bargains. A plea bargain is bargaining with the Crown or a city solicitor representing the city of Fredericton for a bylaw matter, where they say, okay, the Crown or the city solicitor representing the city of Fredericton will say, we'll make you a deal. You plead guilty, we'll make a submission to the judge, you get a lesser sentence, lesser fine, lesser repercussions. Now this plea bargain goes on without the court supposedly knowing about it, and what ends up happening is, after the plea bargain is reached, a defendant is told, I'll give you a Criminal Code of Canada matter, okay, this is how it would happen. I've heard of this happening before by more than one person, so it's standard practice for the Crown. What they'll do is the Crown will say, okay, there's 10 charges or 15 charges against you. Now it's important to know that the Fredericton Police Force, or just about any police force, will trump up charges. What that means is they'll charge the defendant with everything they can possibly think of, knowing full well that most of it will never stick, most of it will never be fully prosecuted, and the individual will never get a guilty plea on most of it. They just put it in there as an intimidation factor. So if someone's caught doing something, or allegedly caught doing something, that one thing they're caught for is a single charge. Or the one thing that the police force are asserting is basically a single charge, and then they'll add a bunch of other charges just to fill up the docket. And what they'll do is, say it's an assault charge, well then they'll add a whole bunch of other criminal code charges in there, anything they can think of. And then it's up to the Crown prosecutor to actually make that stick or prove the guilt of the individual. Now, if someone pleads not guilty, the consequence is the Crown has to prove every single one of those charges with enough evidence to convict the defendant beyond a reasonable doubt, which means there cannot be any doubt whatsoever they did it, or a not guilty verdict is entered. The implications of that are very dramatic, and I want to reiterate that. If one is charged with violations under the Criminal Code of Canada, you're only supposed to be convicted if the evidence is sufficient to prove beyond a reasonable doubt that the defendant is guilty. A guilty verdict will be rendered. That's how it's supposed to work. So it's actually in everyone's interest to plead not guilty to every single charge, make the Crown prove it beyond a shadow of a doubt. If they fail, you're acquitted on those charges. Now, what people are faced with is they're told by the Crown and the police and their defense lawyers usually that, okay, here you go, there's 10 charges, that you're being charged with. The combined total could be jail time of 2 to 10 years for all these charges. It doesn't matter how frivolous the charges are, or how groundless, how baseless the charges. They're just told, okay, you're facing up to 10 years in jail if found guilty on it. Now, both the Crown prosecutors and the defense lawyers know that 9 out of 10 of those charges will never stick. There will never be a guilty verdict rendered on them. No way. Unless there's some major corruption going on. So really, there's only one charge that's the one that there's any evidence on. So knowing this, you got to remember, the Crown prosecutors know this, defense lawyers know this. They know that 9 out of 10 would just be dropped if they went to trial. Still, they will make a plea bargain with a defendant and say, listen, you're facing up to 10 years in jail for these 10 charges. If you agree to plead guilty to the main charge, or maybe 3 of the charges, they'll say out of 3 out of 10 charges, well, you plead guilty to those, say you're guilty. If you do that, we'll agree to drop the other charges and we'll ask for a lesser sentence for you. So what someone is basically being told is that you're either going to face a possible 10 years in jail, or you might only have to serve less than 2 years or a year for the 3 charges you're going to plead guilty to. Now, it's actually illegal for the Crown to do this. They cannot promote that someone plead guilty to charges they're not guilty of. If someone says, I am innocent, the Crown cannot make a plea bargain like this and say, they can't say just lie and plead guilty when you're innocent. It's actually illegal. It's fraudulent. You cannot commit fraud in court. They do it all the time. And many people I've talked to have had this experience. And what will happen is that the defendant, thinking they're going to somehow get lesser time than possible and wanting the whole thing to be over quicker, will agree to the plea bargain. They'll say, yes, okay, I'll plead guilty to these 3 charges, which I'm innocent of, but I'll plead guilty, and then I'll get a lesser time in jail. And what ends up happening is they schedule a day, and someone pleads guilty. They say, to the court, they say, I plead guilty to these charges. I did it. I did every single one of them. I did everything that's claimed against me. I did it all. And I agree with all the allegations against me and all the witness testimony. Which means you're totally agreeing to the entire Crown's case against you. Now, you can't turn back from that at a later point, because either you cannot testify in your own defense because now you're no longer a credible witness because you've just lied under oath or made assertions that were not true, and you can't actually, in your own defense, your testimony would be basically worthless. So the Crown has you either way, and you're basically screwed. Now, after one actually gets up in court and says, I'm guilty, I agree to every charge against me, I agree to every witness testimony against me, it's all true, there's no guarantee that the judge is going to go for that, and there's no guarantee that even though the Crown said we're going to argue for a lesser jail sentence, that the judge has to go for that. The judge can still give maximum penalty anyway, even though someone pled guilty and admitted to everything. They could still get 10 years in jail for 3 charges that they thought would only get them a year. The 3 charges might have been sufficient to consecutively give a 10-year jail sentence. You never know what the judge is going to do until he's done it. And then that's what appeal courts are for, to appeal those decisions that are wrong. So I just wanted to give this information. I've talked to a lot of people who are in jail now, or they're going to jail, or they've been in jail, and the reason for it is they've accepted these shady plea bargains where they've agreed to be guilty when they're not, and they're actually innocent. And if they had just gone to trial, they might have spent almost a year in remand, but they would have been found not guilty and would have been released. Instead, rather than going to trial and making the Crown prove the case, they just plea bargain, claim to be guilty of things that they're not, and then get years in jail anyway. So, a big warning to everyone, plea bargains are never good for you. For one, the Crown is never supposed to engage in them. If you're innocent, you're innocent. That's all there is to it. You cannot plead guilty to something you're innocent of, or it's fraud. And when the Crown prosecutors engage in these practices, they're actually engaged in fraud. It's wrong on many levels. And the consequences are, there's no guarantee you'll get a lesser sentence. You might have actually got a lesser sentence if you went to trial. and you may have even been acquitted at trial, which means you would have spent a couple months in remand or no jail time at all. So if you're innocent, assert your innocence, make them prove their case. Never plead guilty if you're innocent, and if you're guilty, it's up to you if you want to plead guilty or not. If you think you're going to get a lesser sentence, good luck to you. It's in everyone's interest to plead innocent and let the Crown prove their case beyond a shadow of a doubt, which is really hard to do. Thanks all for listening. This is Justice Under Cheap in Fredericton, New Brunswick, Canada. Have a great day. These are my thoughts on plea bargains and pleas in general. Thank you.